Morning and happy Monday. It feels a bit dim this morning. Hopefully there's been a bit of rain across the state over the last few days. And so my name's Jackie Broman. I'm the owner at TBA Law, and every Monday I come to you at 10 o'clock with a short snippet of legal information. Except next Monday, which is a public holiday, so you'll be waiting after today for a fortnight. All my videos, the live videos, are then saved onto our page, so you can go to the video section on our Facebook page and look at all the back videos to see the relevant topic, and if anything is relevant for any friends, please tag their name in it or send it to them via direct message if it's a little bit of a delicate area. So today I wanted to talk about claims against wills. On Friday I did a half an hour Facebook Live on estate planning and did cover off a little bit on claims, so you can have a look at that, and the claims section was sort of 20 minutes in or so, it was towards the end. But as a shorter snippet today, claims against wills, most people think of them as what we call a family provision claim. So in Australia, we have what's called testamentary freedom. So you can do whatever you like in your will. In some other countries, you don't have testamentary freedom necessarily. So in some countries, the government says how your estate is to be inherited. In some countries, part of the estate has to go in accordance with the government laws, and the other part you do have testamentary freedom. But in Australia, we have complete testamentary freedom in all states. However, that is then curtailed. In each state, there is legislation that if you don't meet your obligations to people that you owe a duty to in your life, they are able to make a claim. Not saying that they will, and not saying anyone will intervene on their behalf. However, the law has developed that you do have an obligation to your spouse and your children primarily, and anyone who's financially dependent on you at the time that you pass away. So these are the people who can make a claim against an estate, and it's basically called a family provision claim because they are claiming that you haven't provided sufficiently for them in the will, if you've left them out, or what you've left them is not sufficient to maintain them, and hence they make a family provision claim. All right, so there's a lot of factors involved there as to whether what you've provided is sufficient or not. Other ways people can make claims against estates exist though as well. And because the Victorian laws changed in 2015 around the family provision claims and tightened it up, more and more people are starting to look at these other ways of making claims against wills. So you can make a claim that a will is invalid, for example. So you can question whether the person making the will knew what they were doing at the time. So had they lost capacity, or were they under undue influence? So you can make those claims. You can also claim that the will is invalid because it hasn't met the requirements of the law. So if it was a will kit done at home, and the requirements weren't met, you could claim that it wasn't meant to be their last will. Now that would stand up if they'd done their will kit some years ago and had had plenty of time to do a proper will. Not that a will kit can't be a proper will, but that's a whole other thing. So other than making a family provision claim, you could also make a claim about the invalidity of the will on a number of different grounds. Other claims against estates include claims by creditors. So if they weren't provided for to be paid out of the estate, and the estate is not recognising that they're owed something, they can also make a claim against a will. And the final way that you can make a claim against not so much a will but the estate generally is called an estoppel claim. So estoppel is a strange term that has risen, which is basically someone is stopped from sticking to a promise they've made. So that's what estoppel is. So if someone during their life has promised someone certain things, and that person has then acted to their detriment based on those promises, and then they pass away and in fact what they promised isn't in the will, the person who was promised can make a claim that that they should get what they were promised. So historically, most of those claims were done under family provision, because a good example would be a farmer. So a farmer with no spouse and no children, and his nephew comes to work for him. And the uncle always promises, look, this farm will be yours, blah, blah, blah. And so the nephew works for the farmer for 20 years, works for less pay than he would have otherwise done because he thought that he was going to get the farm. And then towards the end of their life, the farmer and the nephew have a falling out, and the farmer just decides to do something completely different in his will. Then the nephew would have a claim under what's called a stopple, because the nephew is not eligible for a claim under family provision. So that's where a stopple arises. It sort of catches people who don't fall within family provision, but specific requirements have to be met. So again, estoppel is a funny word which basically means that someone is stopped from not sticking to a promise they've made. All right, so those are the three ways that people can make a claim against a will. In the estate planning process, which we go through, we can minimise most of these methods where people can make claims. So we can certainly do some tricky estate planning stuff to minimise family provision claims against your will. We can explore estoppel. We can certainly do some interesting estate planning there to make sure that there is nothing that can be stopped. And of course, when someone comes to us, we make sure the will's valid. So we obviously know the requirements that are needed by the court, but the other thing is that we cover off certain requirements in terms of testamentary capacity as well. So even if someone's sick, we make our own assessment. We also get a doctor's assessment to make sure testamentary capacity is not going to be an issue. So all of those reasons are then protected against. So it's as near as you can get to watertight. So I hope that that's helpful. As I said, this live video will be saved back in our video section. There's a whole lot of other videos there you can go back and have a look at. If this is relevant for anyone, of course, tag their name in it or direct message them with the link to the video. If you do want to ask me any other questions, you can direct message me through this Facebook page, or of course, email directly at TBA Law. All our emails are on our website, so there's nothing hidden. You can email us directly, or email through to admin@tbalaw.com.au. So I hope you have a great week. I've just heard a little bit of rain again, so fingers crossed we still keep getting some rain across the state. Otherwise, I'll see you in a fortnight. Happy long weekend next weekend. See you then.